All right, welcome to the 32nd meeting of the Fair Employment and Housing Council. Our meeting is being called to order to get us started. DFEH Legislative and Regulatory Council Brian Sperber will perform the roll call.
Chair Mandelbaum.
Present.
Councilmember Brodsky.
Present.
Councilmember Chan. Councilmember Iglesias.
Present.
Councilmember Ortiz.
Present.
Councilmember Shore.
Present.
Director Kish.
Present.
So thank you to those who are here in attendance and to anyone following along online on the live stream. Our meeting is being webcast live and will also be available later on the DFEH website and YouTube channel. If you're not physically present today but are following along and want to participate in the proceedings, you can do that by emailing the council at fehcouncil@dfeh.ca.gov. We'd like to acknowledge, in addition to Mr. Sperber, Tatiana Grant from Business Services, and our tradition is to go around the room and introduce ourselves on a voluntary basis if we'd like, so we know who we'll be spending the day with. So I'll just kind of start here on the left, and if you'd like to introduce yourself, go right ahead.
Thank you. Alan Reinach. I'm the Executive Director and General Counsel for the Church State Council. So I've had testimony previously on the pre-employment inquiries. Also a member of the Legislative Committee for California Employment Lawyers Association.
Good morning, Noah Lebowitz, here on behalf of the California Employment Lawyers Association, Fair Employment Housing Council Regulations Committee. Yeah, Mark Renning-Smith, Program Director at the SICK Coalition, which is the nation's largest SICK civil rights organization. I'm sadly not going to be able to stick around in person for long, but colleagues are following online, so thanks for having me.
Mark Murray from the California Teachers Association.
Bruce Wick, California Professional Association of Specialty Contractors, CalPAS.
Naomi Young, I'm the Fair Housing Program Manager for Bay Area Legal Aid.
I'm Matt Warren, I'm a housing attorney with the Western Center on Law and Poverty.
Good morning, Sheridan Nicolau with the California State Council on Developmental Disabilities.
Bailey Stroh, summer intern at National Housing Law Project.
Beth Avery, an attorney at the National Employment Law Project.
Amanda Eaton, a summer intern with the National Employment Law Project.
Good morning, I'm Nelson Shannon, an assistant chief counsel with the Department of Fair Employment and Housing.
Oh, good to see you. It's been a while. Well, thank you all for being here, and we look forward to you participating as our agenda unfolds. Our first order of business is to review that said agenda. By the way, the meeting materials are here in the front of the room. If you don't have copies, you can get them, and they're also available online if you're following along on the same page that the live stream is on. Today's meeting will feature a public hearing on the proposed employment regulations regarding religious creed and age discrimination, along with updates from our various other subcommittees. As always, there will be opportunities to comment on each agenda item as it unfolds. Our first order of business is to approve the minutes from our last meeting, which is attachment A to the meeting materials. And highlights from our July 3rd meeting in LA included consideration and adoption of modified text of proposed fair housing regulations, consideration and adoption of text of proposed employment regulations regarding criminal history, the California Family Rights Act, and the New Parent Leave Act, and updates from our various other subcommittees. So any council member comment regarding the minutes? Any public comment regarding the minutes? Hearing none of either, I will move for adoption of the minutes.
So move.
All of those in favor say aye.
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 Any nays? Any abstentions? All right, the minutes have passed. Next order of business is council member reports. We'll obviously get subcommittee-specific reports throughout the day, but anyone on the council have anything they'd like to report outside of the context of their various subcommittees?
The one thing, as we all know, the California banned hairstyle discrimination, and I'm wondering if that might be something that a subcommittee might want to look at. So we could, if that's of interest, we could take a look at that when we come to the subcommittee agenda.
That's a good time to visit that. Any other council member reports? All right. Hearing none, we will move right along. to a report from the greater department. And for that, I'll turn it over to Director Kish.
Not a ton to report since our last meeting was this month, but I do want to say, I see Beth Avery in the audience and maybe a couple other people, that our new outreach and education executive, Brandon Butler, has been really focused on reentry events, helping people coming out of prison looking for work and housing to understand their rights under the Fair Employment and Housing Act, in particular the Ban the Box Law or the Fair Chance Hiring Law. I participated in an event with him in LA last month with a couple hundred people, including people who were part of the reentry community coming out of prison and also service providers. And I can count on maybe 2 hands the number of people who realized that we are here and are enforcing this law. So Brandon has been going around. He's already completed an event in the San Bernardino Reentry Coalition, I believe, and we'll be doing San Diego soon, and then we'll be coming up here to the Bay Area. But I just want to encourage anyone here or listening to let us know if there are events for the reentry community so that we can go and present and help people understand what their rights are.
Thank you, Director Kish. All right, we've come up to our public hearing on the proposed employment regulations regarding religious creed and age discrimination. So, without further ado, we are on the record. It is about 10:15 on Wednesday, July 31st, 2019. We are here in Oakland. My name is Chaya Mandelbaum, chairperson of the Fair Employment and Housing Council. Joining me today are members of the council members Dale Brodsky, Dara Scher, Tim Iglesias, and Joseph Ortiz, as well as ex officio member and director of the department, Kevin Kish. Even though we have made initial introductions, let me again welcome you to the hearing portion of our meeting. The purpose of the hearing is to receive public comment regarding issuance of amendments to the Fair Employment and Housing Act, employment regulations regarding religious creed and age discrimination. This rulemaking action clarifies, makes specific, and supplements existing state regulations interpreting the FEHA set forth in Government Code Section 12900 et sec. As it relates to employment, the FEHA prohibits harassment and discrimination because of race, religious creed, color, national origin, ancestry, physical disability, mental disability, medical condition, genetic information, marital status, sex, gender, gender identity, gender expression, age, sexual orientation, and military and/or veteran status. The proposed regulations are slated to appear in the California Code of Regulations, Title II, Sections 11016, 11063, 11075, 11076, 11078, and 11079. Copies of the proposed amendments to the FEHA regulations are available in the front of the room and are reflected in Attachment D to today's meeting materials. The notice and initial statement of reasons are attachments B and C, respectively. The council also has the text of the proposed regulations available along with the supporting rulemaking papers on its webpage at www.dfeh.ca.gov/FEH Council. We're holding this hearing as part of our formal rulemaking process. The hearing was noticed through the California Regulatory Notice Register on June 14th, 2019, and also via email blasted out to more than 7,500 individuals and stakeholders that are part of the council's email list. So pursuant to the notice, we're taking testimony on the proposed regulations here today, and we will accept written comments on the proposed regulations until 5 p.m. today, July 31st. You may email written comments to the council at fehcouncil@dfeh.ca.gov, or if you prefer, you can mail them to the council, care of Brian Sperber at the DFEH's Los Angeles office, which is located at 320 West 4th Street, 10th floor in Los Angeles, California, 90013. So if you brought a written copy of your comments and you do not plan on separately or have not already separately submitted them via email. You can give a copy to Brian Sperber here today. If you don't have a written copy, you can still email a written copy or provide it in any other fashion as long as it is received by 5 o'clock this afternoon. Anyone who testifies here today or submits written comments will receive a copy of any changes or amendments that are made by the council, and as will anyone else who so requests. Anyone who testifies will have a 15-day period, as will anyone else who chooses to make it, within which to make written comment if there are further changes made by the council to the proposed regulations. We'll consider each comment made here today as well as all written comments received. The council will respond to each of the comments in its final statement of reasons, which will become part of the council's rulemaking record. So the hearing is being transcribed by a certified court reporter, and the transcript of the hearing will be, as well as all written comments received, will be part of the official rulemaking record. Because this hearing is being transcribed, it is critical that anyone speaking does so clearly and that only one person speaks at a time. So you will not be sworn in today when you testify. However, we do ask that you come to the front of the room and speak into the microphone so that the court reporter can take down your testimony and that the council members can hear it. Please begin by stating and spelling your name and stating any affiliation you're here representing. And also, if you are commenting on a specific regulation, please identify the section and subsection of the regulation so that we may refer to it while you're providing your input. We will hear testimony until all those wishing to testify today have had an opportunity to do so. Does anyone have any questions on the ground rules? All right, hearing none, we're ready to begin. So whoever wants to kick us off can just come to the front and provide your comments. Don't make me call on you.
Hopefully I'm not the only commenter. My name is Bruce Wick, W-I-C-K, with the California Professional Association of Specialty Contractors. Our members operate throughout California, and so I just want to thank you, Chairman Obama, council members, Director Kish, for this opportunity. You will receive by email, I believe today, a letter from Cal Chamber with some detailed information, and we are a assignee onto that letter, so I won't go into any of that in detail. I did want to make a few general comments and then a couple of specific comments regarding the regulation. My members would be usually considered medium employers, but I want to speak today for small and medium employers. Google and Apple were once small employers. They were encouraged to grow. And right now, across California, employers I meet, they believe the liabilities from growth are greater than the potential reward for growth. People say, I will grow my business outside California, not within California. And this has impact on what we're doing here today because it's additional regulations. If they're not vetted appropriately and really accomplish what we're trying to accomplish, it adds to that burden of someone saying hiring people and growing is a liability. And I'm going to speak maybe more about age discrimination because I'm well past 40. So, and I need to keep working. So I want to, I appreciate, protection. I know, friends and colleagues who are my age and, struggling to find positions. But when businesses aren't growing, they don't typically need experienced, knowledgeable, mature people who maybe have managed folks in the past and have those kind of skills and abilities because they're just replacing people that maybe retire and usually hiring from within. So we don't get that dynamism of growth that helps people really of all ages. So I do appreciate, our many laws and regs, but I'm afraid some of this may be counterproductive to people if we add too much, again, more regulation, we just quell hiring of people. My employers compete with underground employers. We know there are bad employers out there, and we need enforcement. It's a real important thing, but there are a lot of good employers, but again, small employers. If you have 7 or 23 or 50 employees, you don't have general counsel on staff. Your HR person is maybe part-time. And trying to take more regulation on, implement it, and do the right thing, a whole lot of employers want to do the right thing. It just gets more confusing as we grow. So, some parts of these regs are good. Some parts, I think, are, though, counterproductive to the last sentence in the economic impact analysis to reduce litigation. I think they might add to that. And, one of the problems we have, the more complicated the regulation, what a lot of employers face is in California. I know one employer that sets aside $500,000 for litigation, and they've never been found wrong, but they get involved in annually for litigation just because you can get sued for something and there's not real clarity on whether you were wrong or not. So this is where vetting regs gets really important. So a couple of examples. It appears in this reg we want to give guidance in the regulation itself with examples and things. And that can be hard for a part-time, even a full-time, HR person who has all the other responsibilities they have. How do they sort through? Where Q&A is a way better opportunity to give even more examples and give education. I think we sometimes try to put too much into regs and don't balance how much education. For people that want to do the right thing, they can review an educational piece and say, okay, I see what you want me to do now. It's easier instead of trying to sort through a more complicated regulation. A couple of the regulatory proposal spots, 11016C3, things will be closely scrutinized. And it almost appears that there's a presumption that you violated. And you have to unprove. You're not innocent until proven guilty. And again, this is where you get in litigation, and you wind up spending a lot of money just to get back to ground zero. 11076A, the disparate impact. Again, a lot of them. That's a very good educational piece for employers who don't understand. They may be taking some action that seems innocent to them, seems fair to them, but maybe there's a disparate impact. Why don't we do more education instead of if you have 12 employees and you're the part-time HR person, do you have the time to go through and identify every possible alternative practice? Maybe not, but that's what you're being held to in this regulation, it appears. And then 11079A talks about a reasonable person. The concern there is if I'm hiring someone, and again, I'm in a small business, I don't have that much time to go through it, I maybe want to narrow a pool and not get 500 resumes on my desk or on my computer and say, how do I non-discriminatorily work through this list of people to find the best qualified person? So maybe I want to reasonably, from my perspective, narrow that list down, but someone who's never been in a hiring situation doesn't know that how do you sort through 500 resumes? How can they understand that person? How does a reasonable person look at that? From which aspect? The person applying or the person who's trying to figure out how I find the most qualified person in an efficient manner. So I appreciate this opportunity and so forth. Please vet these well and look at the balance. If there's anything that's duplicative or adds more that doesn't really directly benefit what we're trying to accomplish, I'd ask you to scale that back. Thank you.
Thank you. Appreciate your comments. Additional comments?
Good morning, Council. Alan Reinach, AlanReinach, and I'm Executive Director of the Church State Council, which is a Seventh-day Adventist organization our legal services work has been representing, to begin with, Sabbath observers, our own church members, but in recent years, people of all faiths. But we've represented so many and had so many calls over the years of people who were turned down in the application process because even when I tell them that legally they have no obligation to disclose their need for religious accommodation at the application process, they feel duty-bound, morally bound to be honest and to disclose if they're asked on an application, when are you unavailable? And they'll say, I'm on a Saturday, and then they don't get to second base or to an interview or a second interview or what have you. So my written comments have been submitted. Brian has those. And first of all, I just want to thank you. We've addressed this a couple of times over the years. I certainly feel like this council has not only heard what the problem is, but really rolled up your sleeves and done a fantastic job of addressing it within, your purview, of course, is not to make law, but to really clarify. And listening to the previous speaker, I would reiterate something I think that's in your statement of reasons, which is that by clarifying what needs to happen in the application process, it's going to provide guidance for companies to avoid conflicts. And it will actually be good both for business and, of course, for enhancing employment opportunities for, hundreds or thousands of Californians who are being screened out. And I'm thankful that you added, I had testified about religion in particular, but you added disability and medical condition. And frankly, I was having a talk with someone close to me, just recently about being screened out in the application process because of a disability without really, any proper, inquiry as to what really were the essential functions, which of course applies in disability, but not directly in religion. So, I'm very happy with the work that was done here on, what's the number here? 11063. This is D. Okay, here we go. 11016, and then we've got the big capital B dealing with the applications. And I also very much appreciate your having addressed the online application. And I think that the balance that was drawn there, if it's followed, should be very helpful. Those problems are certainly somewhat in anticipation. We've had some reports of people getting bounced out from online applications, certainly not to the same extent that we do, from people just getting bounced out of the application process generally. When I say bounced out, what I mean is, the online application will ask, do you have any scheduling limitations, or are you available 24/7? And if you don't give the right answer, the application basically terminates. And I think what this would do is then trigger a second question at a minimum that would require the question about, well, do you need an accommodation? And if so, then presumably the application process would at least be completed. And it wouldn't just terminate. So someone would at least have a chance to complete the application. There may be problems that arise in the future. If that becomes a problem, of course, we'll be happy, to let you know and revisit what we're finding. And last but not least, the prior speaker said something about, sort of a presumption based on the scrutiny that would be given. And in paragraph C3, it mentions scrutinizing applications.
I don't see a problem with that language, or that that's somehow going to create a legal presumption. I do think that applications should be scrutinized first by the employers themselves to make sure, and you know, there's some awfully good defense attorneys who make a very good living making sure that they educate their clients on how to stay out of trouble. So, you know, I think that by putting this focus on, you know, lawful applications that are not screening people out based on protected activities, I think it will be helpful to the employment climate here in California. And I'm very grateful for the work of this council. Thank you very much.
Thank you.
Good morning. Noah Lebowitz, spelled N-O-A-H, last name L-E-B as in boy, O-W-I-T-Z. Here on behalf of the California Employment Lawyers Association, the Fair Employment Housing Council Regulations Committee. It's been a while. Nice to see you all. First, we fully endorse the Church State Council's comments and the letter they've already submitted to the council in regard to the regulations, and we will actually be providing a written comment, more thorough written comment about some of the things I'm going to talk about this morning, but we'll also include essentially a sign-on to what the Church State Council has already submitted. So just want to put that in there. Again, we will be submitting a letter this evening or before the close of the deadline today. I do want to talk about a couple of different things in a little bit of particularity in the regs, in the proposal regs. And we'll start with the general section under the pre-employment inquiries under 11016 and the proposed new section B1A. So this section, as explained in the statement of reasons, is more or less a kind of pull out and rewording of the pre-existing language that was in the regulations. So I think this is actually a really good opportunity to take a look at this language and what it's talking about. And as we read it, it actually, the continued essentially maintenance of this language in the regulations is actually a source of confusion. Because there are at least 4 other very specific regulations within the disability regulations that discuss and address all of the various permutations of pre-employment inquiries, medical inquiries, disability-related inquiries, and the timing of those inquiries, what those inquiries, the elements of those inquiries can be or cannot be in pretty significant detail, including the significant detail in the section on defenses related to the health and safety of self or others. So the source of confusion as we read this section as written is that it uses different language, first of all, than the disability regulations. So for instance, the directly pertinent to the position language is not found anywhere else in the regulations. The directly related to a determination of whether the applicant would endanger their health or safety of others, excuse me, is not reflected anywhere else in the regulations. So you're using, what's being reflected here is different verbiage, which of course leads to confusion, which typically leads to litigation. So what we would propose is something that would actually harmonize this section with the existing disability regulations. And frankly, and we'll give you specific language in our letter, but generally speaking, what we would propose is, now I'm getting older, is in what's presently
proposed stop the language as written on the third line and about the middle, where it says, if the inquiry or request, and then from there, cross-reference instead of, basically delete the rest of it, and instead incorporate by reference and specific cross-reference to sections 11070, 11071, which are the pre-employment, 11070 is the pre-employment practices regulation. The 11071 regulation is about medical and psychological examinations and inquiries. And then also 11067 on defenses, which sets out all the details on the health and safety defense. And then also 11065, because it has the two pertinent definition sections related to medical inquiries under job-related and business necessity. And that's really the key language, as opposed to the directly pertinent to the position language, which would cause confusion for someone trying to harmonize this section with the disability sections. So that's how when you put those in there, I think it actually helps clarify and draw the reader to the more specific sections, and that uses consistent language. So that would be our general proposal on that, and again, we'll provide the specifics in our letter. And then just want a few comments on the age discrimination revisions. So first of all, as similar to Mr. Reinach, we have been asking for this revision for a number of years. We first brought it up in December of 2014 in a letter when we were dealing with the general FEHA regs, and we're told that it was not part of the noticed regulation, so we couldn't address it then, and then we asked specifically in 2015 for the council to take it up specifically, and now we're here, so we're very pleased, so thank you for that. And essentially what we were asking is because there was a gap in the regulations. The existing regulations do not specifically address the provisions of Government Code 12941, and the statement in that section that specifically deals with the Marks versus Laurel case and the concept that use of facially neutral criteria for an adverse job action, for instance, being able to pay someone less for doing the same job, can be, not always is, but can be seen as a proxy for age discrimination. It's the general concept under 12941. Stated a little bit differently in the law, but that's generally what the concept is. And so that was our proposal, is to address that, and we're pleased that the council has taken this up. We would propose, though, a couple of tweaks to the proposed language. So in particular, the way the proposed regulation reads gives the impression, at least at this point, that two things. One, that this, the question of kind of the proxy for the facially neutral criteria being a proxy for age discrimination only applies in a disparate impact analysis, when both the code section and the Marks versus Laurel case that was the cause of the revision to 12941 talk both in disparate impact and disparate treatment language. So, and I don't know that it's intentional in the way that it's worded under the proposed language, but our reading of it gives the impression that it's exclusively reserved, that the analysis is exclusively reserved for the disparate impact analysis. So we would propose some additional language, and we'll give that to you later, to address that. And then secondly, that the language as proposed speaks similar to the statute, but the statute is not exclusive to this, in the plural. So in relation to groups of employees, or the impact being on multiple people, or at least the implication from the language as written could be that this this regulation only applies when there are multiple plaintiffs or multiple employees who are impacted negatively by this criteria. I've certainly had clients and potential clients who have called me who have been the single person. They're not involved in a mass layoff. It is a single determination where indeed it's very expressly stated that the reason they're being terminated is for the employer to save money because they can hire someone else to do the same job for half the price as far as wages and cost of employment. Now, there's also, that doesn't win the case. We all know that. That's just one of the factors. But that is a viable claim on an individual case, on an individual basis. And the impression from this regulation as now drafted is that may not be recognized as a viable claim in a viable case. So we will propose some language, I think, that will help address that. And then finally, just generally on age discrimination, I think you all recognize this. But I can tell you, I'm going on 24 years now of practicing exclusively on behalf of plaintiffs in employment cases. And in my own practice, certainly in the past 4 or 5 years, age discrimination, certainly in the Bay Area, is at epidemic levels. I mean, it is just atrocious, especially in the tech industry, more than any other, but it's not the only industry. I was speaking to a potential client just last week, and he was in the financial industry, and he's 49 years old. And he was laid off, and he was calling me about issues with that. But I started asking him, how's the job search going? What are you doing now? And what he told me, it's just, and I've heard this over and over and over again. They walk in for an interview, and the look on the face of the person interviewing them instantly tells them they're not getting the job. And and they've gotten specific comments. Why are you looking at this job? You know, you're way too experienced for this job. Why are you here? You know, what are you doing in this industry? You shouldn't be in this industry. And very obvious comments. And this is happening over and over again. So the fact in general that you're looking at this age discrimination regulation to try to enhance it in the sense of making it more clear and understandable is to be commended, because it is it's a growing problem, it's a massive problem, and it's a growing problem, certainly in my own experience in the Bay Area. So thank you again for all your efforts. We will be submitting our letter shortly. Thank you.
Thank you.
Is it appropriate to ask questions?
Sure. I mean, obviously, we'll be able to respond in writing, but if there's clarified questions.
I'm just wondering if either now or in your comments you could clarify whether under the disability discrimination provisions you think that pre-offer inquiries as to health and disability are even permitted at all under either ADA, Title VII, or FEHA.
That's covered in the disability regs right now. There's a section on pre-employment when inquiries are permissible.
Yeah, if you had any thoughts on that.
Okay.
That'd be great.
I'm happy to address it. Thanks. Great. Thank you very much.
Thank you.
Ask questions.
Additional public comment. Going once, going twice. Brian, anything in writing? All right. Well, since everyone has had an opportunity to provide their public comment as part of the hearing, we will adjourn the hearing portion of our meeting. And again, one quick reminder on the record, please, that we will continue accepting written comments until 5 o'clock today, July 31st. So thank you for being part of the public comment hearing. And with that, the hearing portion is adjourned. And we will pick back up off the record with our regular meeting.
Are council members allowed to ask questions and kind of make comments on it?
certainly we can, although typically that's done at the next meeting since we'll get all this public comment and then
Okay.
there'll be the subcommittee will have a new draft. The draft that's part of the rules that was being commented on today, we've had an opportunity to comment on before voting for it, triggering the meeting.
Okay.
So there's no new draft. So let's move on to an update from Government Code 11135. So I'll turn it over to council members Brodsky and Scher.
Hi, everybody. Big apology. It's delayed again because of me. I'm hoping we will address this in the near future.
So do we have any projection on when, how many meetings that we are out from a notice, being able to notice it for hearing?
It depends on when the next meeting is scheduled, given all the steps that have to take place before we can notice it again.
Well, just to clarify, I think the stage where we are is that the council has already voted to move it into rulemaking, so we would simply notice it and then have the 45-day hearing at a future meeting.
Right.
Yeah.
Right.
Where it is in the process is that we're drafting the initial statement of reasons, and that has to get completed. So to the
Right.
extent that I can help Councilmember Scher with her part, maybe we can expedite it.
We'll do our best. Now
Great.
that the housing regs are hopefully off our plates.
Any public comment on the status update from the subcommittee? Turning now to the subcommittee regarding hate violence, and I'll turn it over to Councilmember Brodsky.
It is working. Councilmember Chan sends her regrets that she was unable to be here. Her term is expiring, so she's been she's been amazing on this committee to try to reach out to stakeholders and anyone else who might have an interest in the subject of hate violence. And she and I spoke yesterday in anticipation of today's meeting, and what we'd like to see happen, I mean, with her, the term having expired, I assume the council will want to appoint another person to the subcommittee. And what she would like to see and what I would like to see happen is that the committee really focus on collecting input as the subcommittee begins the process of drafting regulations. But to do that, we'd really, really like to get input from those who have experience with the enforcement, with specifically under the civil code sections that hate violence, is governed by, and also the intersectionality, if that's what stakeholders see, is the intersectionality between the Ralph Act, for example, and the UNRU Civil Rights Act. And possibly the intersectionality between those two and our statute that prohibits human trafficking under this rubric of hate violence. So that's what we're going to be directing our attention to, and what we'd like to propose is that at subsequent meetings, and this I'm going to segue from that into the specifics, that at subsequent meetings that we put together, we have a assigned slot for individuals and really publicize this as part of it, that if you want to come and provide input, comment on, as part of the public comment, not on a specific set of regulations because they don't exist yet, but on the subject of hate violence, that would give us a lot of help in knowing what direction to take the regulations. So that's what Councilmember Chan and I talked about yesterday, and hoping that we can put together today. The other thing that I wanted to say is that attached as Exhibit E, I think it is, to the agenda is a statement by Eva Patterson, who testified before the House Committee on the Judiciary in April. And I actually have the transcript of her testimony, but as you'll see from the exhibit, she was talking to the committee about hate violence in the form of white supremacy and the white supremacist movement. And Eva was unable to be here today, but but she is very interested in making appearance before the council and talking about what she sees are issues and hopefully providing guidance to us in terms of the direction that our regulations can take. She will be available in the fall, so maybe what we can do is, and the other suggestion that Councilmember Chan and I had, is if we can not only establish a slot on the agenda, but an actual time slot for these comments so that we can then invite people to come. And we were thinking that maybe like right after the first thing on the agenda could be this public session, so that people could come, and if they can't stay the whole day, they know that if they come at 10:30, for example, they'll be able to participate and do that. And we're hoping that Eva Patterson can do that in the fall, the next time the meeting's up in the Bay Area. So that is kind of where we are with that. She and I are both reaching out to other individuals. She's already spoken with a group, Human Rights Commission down in Southern California, and DFEH's training person is going to be working with them. So there's a lot of, it's exciting, and we're hoping that we can get a lot of good input as the subcommittee embarks on writing the first regulations to implement the law. So outreach is what we're hoping for, and with maybe the department's help, we can really not only word of mouth by all the council members, but also coming up with this designated time slot, and then get input that way. Very helpful.
Dale, I think this is great. I'm a little confused about one thing, and then I have a comment. Are you suggesting we do this in lieu of holding a specific public hearing?
That's what Councilmember Chan and I think, yes. Because it's going to be very difficult. Let's say that we have one hearing in the Inland Empire or in Sacramento or wherever. It's going to be hard to get people up from LA and you know, or down to Bakersfield or wherever we're going to be. And we thought that it would be more useful if we target it, if we have like the next 3 meetings, so one in the Bay Area, one in LA, one in Sacramento, wherever they're going to be, have a time slot on there, publicize it, and then receive comment that way, rather than having one hearing in one location that we may miss stakeholders. So that's what she and I were thinking.
And I believe since the direction that the existing subcommittee was going was targeting the part that's most within our purview, which is the regulations, to solicit feedback, targeting, well, how can we as a council, we're not the FBI, clearly they have a bigger role to play in the rise of hate violence, but within our purview, you know, how can we move the ball forward? And so I agree with the subcommittee's approach of like having it be a portion of each meeting. I think we'd need to proactively, as you said, in addition to inviting public comment more generally, I think proactively encourage leaders in the field to come to provide their feedback.
Yeah, and if each of us can reach out even individually to people that we know out in the communities, whether it's at the Department of Justice or wherever, do that as part of the outreach, that would be also helpful.
And I think we absolutely do want to have one of those meetings be in the Inland Empire. So I think we'll prioritize that being one of the ones where this is on the agenda.
So that makes sense to me. We did want to maybe try, the chair's comment goes to this. We did want to, we had 2 goals. One was to hold a meeting in a public hearing in a community where we don't normally sit, and the other was to work on the hate violence issue.
They're not mutually exclusive.
And so this sounds like a great proposal. We may also, and I think holding a specific meeting in Inland may be helpful. I hope when we're more fully staffed on the council, we can also consider a public hearing in a community where we don't already sit. But I'm fine with this proposal. I have a couple of particular questions about it. I found Eva Patterson's comments to the Congress chilling, and always love to hear from her, so I'd love to have her as a speaker. I'm hoping if she's going to lead off speakers, we also have speakers that address this in the context of religion, particularly the rise in anti-Semitism and anti-Muslim hate violence, and immigration. So I think, those are obviously overlapping threads in terms of hate violence. I suppose domestic violence is a little piece of that, but I think really those are the three big threads, is white supremacy, the rise in religious discrimination. Those overlap to a great deal, but particularly the huge rise in discrimination against anti-Semitism and Muslims and the bombings, and immigration, and just how that's all fueled by the current climate, and what if anything, we can do about those things. So that would be my request, that at least a couple of those speakers that we invite to those meetings address those particular topics as part of the discussion.
Yeah, I also appreciated the Eva Patterson's testimony, and I agree with Councilmember Scher that the invitation to the next 3 council meetings ought to be broad-based on these issues, and I'd appreciated it perhaps maybe Councilmember Brodsky, you could actually draft an initial, like, if you drafted something like that's kind of a description of what we're looking for, what we want, and then we could all use it, and then there would be a consistent message to all the people that we're communicating with.
Like an invitation?
Yeah.
That's a good idea.
Yeah, so that we could all then communicate.
Yeah.
And then, as I understand it, Councilmember Ortiz is also working on another meeting that would be down south that this could be a part of, but it then would fulfill some other of the goals.
I think they dovetail nicely, so I'd love that statement, and we could look for speakers on all of those topics.
Okay.
Yeah.
Great. And Kevin, I don't think we have any budget to bring people in as speakers, do we? Or particularly national speakers? I didn't think so. I don't know what I was dreaming. So the only reason I say that is there are several national organizations who are really addressing this in a significant way. The Southern Poverty Law Center, the what are they called? Something church state folks.
Well, that's Mr. Ryan.
Right, but there's a national organization that's done a huge amount of work on some of these issues, and some of them may be willing to send a speaker or may have local people working with them, but
well, that's why we thought it might be good to have, to have it decentralized, so we could get those organizations that also may not have a budget for sending people here and there.
We can also use technology. We'd have to figure out a venue that has video conferencing technology and also a way to include that in our live stream that's not insurmountable. So I think that as the council members prepare to issue invitations, we should be considering very broadly where people are, not just maybe local to the meetings, but also some of these national figures.
Yeah, because there's certainly major national groups working on anti-Semitism. There's certainly groups working on Muslim violence, and obviously Southern Poverty Law Center is one of the leading national organizations. I know Ms. Patterson quotes from them liberally. They put out regular publications, as does the church. I wish I could remember the name of the organization, but it's a national church-state group.
I just want to mention, there are obviously multiple instances of hate violence that occur every day in California, around the country, but there was an attack last week on a priest in a Sikh temple near Modesto who an intruder broke into his house, punched him, and told him to go back to his own country. So that's been in the news. And I think, although the gentleman from the Sikh Coalition had to leave early, I think it would be great to invite someone from that group to talk about hate violence against the Sikh community particularly.
To the subcommittee, if you could just email suggestions, or maybe Brian, you could be the conduit for that.
Yeah, you should tell us the suggestions.
Yeah, so that then we can, once we get this invitation going or whatever, we can target.
Yeah.
Right, I think the council or the department can help with that, and we'll go back. We'll revisit this in a later agenda item because we'll need to kind of reform the scope of the subcommittee and add a subcommittee member. So we'll do that in the agenda item tackling subcommittee assignments.
Yeah.
Any public comment regarding the hate violence discussion?
Yeah, Mark Murray from the California Teachers Association. I just want to continue to offer our support in terms of resources. In case you didn't know, the National Education Association last year passed a bunch of resolution language around white supremacy culture. And then just this summer, just a couple of months ago, we passed some new stuff around the concept of white fragility, which is the idea that people who are sort of well-meaning in their attempts to help out with issues of race and issues that we're talking about here get defensive, and it becomes difficult to have these conversations. So the National Education Association is working on training for our members, which would also be available, I'm sure, to anybody else around some of these issues. So I wanted to continue to offer our resources and our support. We think it's great work that you're doing, and we want to help in any way we can, especially around issues of possible education pieces that we want to put in place, maybe in the schools. So I look forward to working with you guys in the future on some of this stuff.
Thank you. Any other public comment on this item? All right, hearing none, we're moving right along to an update from the SB 1343 Implementation Subcommittee, and that is a subcommittee I was on since our last meeting with Councilmember Chan, and I just want to echo Dale's comments. It's been a true pleasure to work with Councilmember Chan, and she's brought a real thoughtful and committed approach and contributed during her time significantly to the council, and including to the subcommittee that I'm going to discuss. So basically, as a reminder, at our last meeting, we discussed how SB 1343, which is the new sexual harassment training law, which expands the scope of who is required to be trained. It now includes all employees, not just supervisory employees. And the current deadline is January 1st of 2020, so it's coming right up. There have been a number of questions from members of the public, stakeholders, about how to apply this law in various contexts, and some of those are what we examined. The last subcommittee, which was formed at our last meeting, so it's only existed for the month of July, was specifically charged with following pending legislation, which is SB 778, which would extend the deadline to complete this training under the new law to January 1st, 2021, so it would extend it by a year. That legislation has advanced out of the Senate, and it is progressing in the Assembly. It is not yet passed or signed into law. So we'll continue to keep an eye on that, but it's clear that whether it passes or not, the public would benefit from some regulations that clarify SB 1343's requirement in various specific contexts. We talked about some of them at our last meeting, such as the education of minor employees who are employees but can be as young as 5 years old. How does that interact with the requirement of sexual harassment training? Union hiring halls. There's a various contexts where the law itself doesn't necessarily speak to or contemplate how it should be implemented, and those are the types of things that would be addressed in the regulations. If SB 778, the extension legislation, does pass, then we would contemplate just having a regular rulemaking process for the clarifying regulations. If it doesn't pass, given the upcoming deadline, which still is January 1st, 2020, some or a portion or all, based on our review of the proposed regulations, would be emergency regulations, so that they're in effect by the time employers are required to comply with the law. So that's kind of the update of where we are. In our next or a subsequent agenda item, when we talk about subcommittee assignments, we will form a subcommittee with an expanded charge of actually drafting regulations, and includes 2 subcommittee members.
Thank you. I support paying attention to this. I just got a notice from my employer that I have to attend a mandatory sexual harassment training because of this new law, because of the existing 2020 deadline. So thank you.
Along those lines, is there a report from the department just about the training? Sorry to put you on the spot, Director Kish, because actually I was thinking about it in the context of our own law firm as well, the training resources that are contemplated in 1343.
Sure. SB 1343 requires the department to produce an online interactive training, subtitled and dubbed into different languages, with the possibility of people who take the training getting a certificate of completion at the end of it. We prepared a detailed request for offer for vendors to develop this training, and we received no offers. So we have asked a respected senior IT leader in state government to come out of retirement and work with us. She is starting this week to put together a training. And, we'll have something up if this pending bill is not signed into law. If the pending bill is signed into law, obviously my goal would be to create a training that's actually very good, that incorporates some of the best practices that have emerged from social science, from the EEOC's special task force on sexual harassment specifically. If the bill does not pass and is not signed into law, then we'll have to put up something that is compliant, but will probably be less comprehensive.
Can I just request in response to that, that you consider hiring a consultant on accessibility as part of developing that training, and I can make some recommendations.
All right. So any comments specifically on the status update for SB 1343 and the contemplation of forming a subcommittee to address various contexts where regulations would help with implementation? All right, hearing none, we're going to move along to consideration of the unmodified text of the proposed fair housing regulations, which is attachment F to the materials. And I'll turn it over to Council Members Schur and Iglesias.
Attachment F is as the chair said, the unmodified text of the fair housing regulations that have been processed now for, I can't tell you how many years. You're hoping, again, this is the last step in the process. There are very minimal changes indicated in the text in wavy underline as additions or strike through and italicized that we discussed at the last meeting. There was a comment period on that ended. If anybody has additional comments on those proposed changes, we'd be happy to hear from you.
I just want to reiterate, how impressed I am with the subcommittee, and this has, like you said, been a really long process. Understandably, this is the first fair housing regulations that have existed under FEHA, so it's a big lift, and kudos for sticking at it, and I think this is a great draft.
Well, we now have until essentially the 3rd of August to submit the final rulemaking package. The final statement of reasons is done, absent any responses to anything today, then ready to go in before the 3rd, and then OAL has 30 days to review the whole package, including the updated final statement of reasons. And then my understanding is it would become effective in January. Is that correct? January 1st of 2020.
All right, well, unless there's any council member comments, we can turn it over for public comment. All right, hearing none, we'll start with public comment.
Hi, I'm going to be very brief. Kara Birdfear, I'm from the National Housing Law Project. I've been working with many advocates over many years. with many of you in working on these regulations, and we just want to lend our support again and thank the council for their thoughtful and incredibly thorough process in making this happen. And we're anxiously awaiting the final regulations and the ability to use them to advocate for our clients. And again, we urge you to submit them, and we're very excited to use them. So thank you very much.
Thank you.
Thank you.
Good morning, Matthew Warren with the Western Center on Law and Poverty. Just want to reiterate Kara's comments. Thank you so much for your hard work on this multi-year process. We're really looking forward to adoption of these regulations and using them for our advocacy.
Thank you.
Any other public comment? Anything in email? All right. With that, I would move to adopt the proposed final text of the fair housing regulations that are in attachment F, authorize the department to submit the rulemaking package to OAL, and authorize the department to make any non-substantive or non-substantial changes required by OAL in order to approve the regulations.
So moved.
Second.
All those in favor say aye.
Aye.
Aye. Any nays? Any abstentions? All right, the motion passes unanimously.
All right.
So our last substantive order of business is to revisit subcommittee assignments. And as we discussed in our other various agenda items, there are at least a couple that I know that we need to form. One being an SB 1343 implementation subcommittee. And I will bracket employment regs generally here because we may want to add that or not. But I know, for instance, the new hairstyle discrimination law is another employment-related thing. But I'll bracket whether we want that in a different subcommittee or this one. But at a minimum, 1343. We also have the hate violence subcommittee, an expanded version of that would tackle regulations and spearhead hearing participation. And I guess I would also bracket, and I think we would want probably for that to be the same subcommittee that plans a hearing, just because there are some overlap, and for logistics reasons, it would be good to have the ability to communicate on that, but that's not a requirement. But I guess maybe a good place to start would be figuring out who wants to be on these and whether we're kind of right.
They all sound great, but yes, since I've had the interest in forming and having a hearing in the inland region of Southern California, I think it'd be a natural fit for me to be on the hate violence subcommittee.
So what if we had council members Brodsky and Ortiz on that, both sides of it, the regulations and the hearing, and then I'd be interested in continuing what I've started on 1343. Is there someone that would like to join me on that process? Don't all raise
Can
your
we
hand
also
at once.
just maybe run through the existing subcommittees so everybody knows who's sitting where? So we.
And sorry to interrupt, but we don't have any idea when the vacancy will be filled.
No, we do not.
Thank you.
11135 is existing with council members Shore and Brodsky. We have religious creed and age. And did we add?
Councilmember
Yes.
Iglesias and Ortiz.
Okay.
We've got
Iglesias
the
and Ortiz.
Yeah.
Housing, I don't think we are dissolving since that
Right.
package. Okay. Which is Iglesias and Shore. We have the criminal history and employment package, which is going to be submitted to be entered into the register soon, and that is Mandelbaum and Ortiz.
Right.
Okay. And then, okay. All right.
So, I mean, I can certainly spearhead 1343 if people feel like they have limited bandwidth, and at the next meeting we can add a subcommittee member if there's not a new appointee. So no pressure, but if someone's interested in jumping on right now, we can add someone now.
You willing to do that? To
Yeah.
do it on your own?
Yeah.
That sounds,
Okay, so why don't I do that at least till the next meeting, and then we can always see where we're at in terms of resources and bandwidth. That would be the two that I think at the next meeting, especially in light of all of our other projects that I think we do, unless anyone has any other comments on that.
do we have we talked about dates for the Inland Empire? Or, one reason I'm asking is because just for scheduling purposes, but also if we want to get a set of regulations, at least a draft, not a year from now, but more imminently, it would be helpful to come up with some scheduling.
Well,
for
so
both
that's
that
something we
meeting
can.
And for our, also our subsequent meetings in other locations.
So I've reached out to stakeholders in that region, and I've used the general timeframe of October, but that's not set in stone. And I think the council would need to set a date first in order to lock in speakers. So perhaps what we need is a doodle poll or something of that nature. I think anytime sooner than October I think would be problematic. So sometime in the fall or early winter I think would be appropriate.
Well, so that should be easy enough to accomplish for a regular meeting. A hearing, I'll leave it to the subcommittee about kind of that can be a big lift in terms of how quickly that can be arranged. But I agree, let's just do doodle polls, I imagine, our next meeting. In addition to having a set agenda item for the hate violence issue, will probably include the hearing on criminal history and the new Parent Leave Act, along with various, a second draft of religious creed and age and other items.
So the sooner we could schedule another meeting, the easier it will be to get speakers to come. So if we could schedule our, whatever, would that be in September?
Well, we'll have to look, that's probably right. We'll have to look about the timing. Probably the next meeting we'll have the public hearing on CIFRA and new parent leave.
Yeah, we're gonna need the 45 days, plus 10 days for OAL review up front once we have the final go-ahead to submit the package.
So I guess this is something we can do through doodle polls and scheduling after the meeting.
So does that mean, and I'm fine with this, that we're going to defer any consideration of regulations on the hair amendments until, we have a little more staff? I looked at them. I didn't see anything that cried out for an immediate regulation.
That's kind of my thought. We can see where we have more staffing and also what comes out. I mean, for example, in 1343, it's been helpful to hear from the public about, hey, we're trying to implement this and this is unclear. I don't know that law has been around long enough for us to get the feedback that indicates that regulations are necessary.
And we also have regulations that do cover physical appearance.
Right. Okay, any public comment on subcommittee assignments? Hearing none, I will move for us to adopt the assignments we discussed for 1343 and hate violence.
Second.
All those in favor say aye.
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 Any nays? Any abstentions? All right, motion passes. So our final order of business for today's meeting is public comment that's not specifically tethered to one of the subcommittee items we addressed. So if anyone wants to provide more generalized public comment, now's an opportunity to do that. Seeing no movement. Brian, any written comment? All right, with that, we have wrapped up today's agenda, and details regarding the council's next meeting will be available in the coming weeks on the webpage. So thanks for attending.
Thank you.
Thank you.